So the next thing I'd like to go over is prior art searches. Now, what is a prior art search? Well, a prior art search is a search to find anything that could get in the way of an inventor getting a patent on an invention. So when do you do a prior art search? Well, I think you should do one right at the beginning, before you spend any serious money on getting a patent application filed or on developing a prototype or going to investors. You really should find out whether or not your idea may or may not be patentable. So what does a prior art search look for? Well, a good prior art search will look for any publication or product or appearance or anything out there that would show that the inventor has publicly disclosed his or her invention, or that somebody else has come up with a similar invention and has publicly disclosed it. So with most inventors, I suggest they do their own prior art search first, and this would include looking on eBay, looking on Amazon.com, searching through Google Images, basically looking for any products that are out there that are similar to your invention. The second part of the prior art search is to get on the various patent databases and look for any published patent application or actual patents that may be similar to your invention. Now, when you start looking online, my suggestion is you start with Google Patents, Free Patents Online, and Patent Storm. These are three private patent databases that are very well managed and fairly easy to search using keywords. After you've searched on these patent databases, my suggestion is you go over to the United States Patent and Trademark Office database, that's uspto.gov, and look under issued patents and published patent applications. Now, the goal of the search for published patent applications and issued patents is twofold. First of all, are there other patents out there that may prevent you from even making your invention? In other words, are you infringing somebody else's patent? It's pretty important to know that before you start manufacturing or before you start asking for investment money. The second aspect of the prior art search when you're looking for patents and published patent applications, again, is whether or not there are issued prior art out there that may impact your ability to get a patent on your invention. Now, once you've done your own private search by yourself, my suggestion is you turn your results over to one of the professional prior art searching companies. Some of our clients have had really good luck with National Patent Services and Legal Advantage. Those are just to name two. But when you go to a professional prior art searching company, you're going to a company who basically has as their business looking for prior art. And so if you show them what you've found, they're more likely to spend the number of hours they have allocated to the prior art search looking for things you haven't found. A lot of inventors say, well, I want them to earn their money. I'm not going to show them anything I found. Well, that's fine. Then they'll probably spend the first half of the time they have allocated to your prior art search finding the stuff you've already found. So my advice is show them what you found, have them focus on finding things you haven't found. Once you get the results back from the professional prior art search company, it's time for you to sit down, look at what you've found, look at what they've found, and try to make an assessment about what your chances are of getting a patent. Now, at this point, you can ask for a patentability assessment from an intellectual property attorney. We can look over the patents that were found in the published patent applications, and we can compare them with your invention and give you a fairly realistic idea of your chances of getting a patent. However, there are a couple of limitations to patentability assessments. First of all, they're good under the laws that exist at the time we see the prior art search, not necessarily at the time your patent application would be examined. Now, just in the last 6 years, the patent world has seen some major changes come down. We've had three very important cases dealing with patentability. Certainly on the utility patent side, the KSR v. Teleflex and In re Bilski were very important decisions. And then in terms of what it takes to infringe a design patent, Egyptian Goddess was a very important case. We've had, in the last 10 years, we've had four now, directors of the USPTO, and we've had the Patent Reform Act pass. So the patentability assessment, it may be fairly accurate today. However, since it usually takes a year and a half or so for a patent application to be examined, the laws today will not be the laws a year and a half from now, and we cannot give a patentability assessment based on what we think the laws will be a year and a half from now. So that is an inherent limitation in the patentability assessment. The second limitation is often a budgetary one. Patentability assessments take a fair amount of our time. We have to spend on the average about an hour on each patent going through the claims, seeing if the claims cover what you're doing or how close they get to what you're doing. And so you can expect a fairly hefty legal bill if you turn over the entire prior art search results to us and ask us to assess your chances of patentability. That's usually not a very good use of your money. So if you are going to go for a patentability assessment, my recommendation is you just pick the 2 or 3 most dangerous patents and ask us to look at those.